Hi, folks. This is Bernie Wolfsdorf. It is a great pleasure to have you all join us today. I'm going to give a minute or two for folks to log on in order to fill the time. We have two guest speakers today. Firstly, my partner, Joe Barnett. Joey, thank you for your work in putting the PowerPoint together. We also have the former chief, and I emphasize former chief, Charlie Oppenheim, retired very recently after 43 years of service to the U.S. Department of State. And Charlie's name is pretty much synonymous with visa reporting, visa controls. There is no one that I know as knowledgeable as Mr. Oppenheim in connection with visa controls, visa allocations. So we are very fortunate to have Charlie join us today. In order to give people time to get on, log in, there's always a few stragglers. I'm going to start the presentation with my partner, Joey Barnett, giving a brief overview of the new law so that people understand the big picture. I will emphasize that Mr. Oppenheim's expertise lies in the area of visa control. Mr. Oppenheim will be addressing some of the more complex issues such as visa set-asides, visa waiting lines. I will also put in the standard legal disclaimer. Nothing that we or Mr. Oppenheim provide today constitutes legal advice. Mr. Oppenheim is not representing the U.S. government or State Department. Any views he expresses are purely his own personal views, and I might point out that they are preliminary. Mr. Oppenheim no longer has access to government data or statistics, so he hasn't looked at much of the official information. And on a personal level, I'm hoping that the State Department will rehire him as a consultant to advise them and everyone else on the meaning of some of these provisions. So without further ado, Joe, let's go through some of these slides for a few minutes, fill people in on the current status. I want to question your first point. I thought that the president signed on March the 14th. You've got March 11th. When did he sign? Because it's effective 60 days after, right?
You're right. It happened a week ago on the 15th. And
oh, we're both wrong. Okay.
Yeah,
the 15th, because it's 60 days. 526s for regional centers cannot be filed for 60 days from that date. So this is incorrect. It's actually March 15, 60 days. Would that be May the 14th? Have you done the math on it?
Right, which is a Saturday.
A Saturday. So we can't really file on the Saturday. We'd have to file on the Friday for the Monday. But anyway, back to you, Joe.
Yeah, so before we get into Charlie's insight, I just wanted to take 5-10 minutes to discuss what this new EB-5 legislation means on immigrant investors, both existing and future investors, and provide some context on what is still unknown. As I'm sure most of you know, this bill has been negotiated for nearly 7 years, and it's never pretty to watch a sausage being made. We understand it's not a perfect bill, but it is something, and it gives relief to existing investors who've been in limbo for the past 3/4 of a year. And it gets the US government back to work with regards to their commitment to these EB-5 investors, which have been used to create jobs for US workers. USCIS did update their website earlier in the week, so they are aware of the legislation, which is great. They state that they are reviewing it and that they will be providing additional guidance. That's all that they have said publicly. Bernie and I are on the ALA EB-5 committee. We have written The committee has written them and asked for some engagement, and we pretty much got the same response back there as well. So there is a lot for these government agencies to read through and to figure out. And that's part of this 60-day process, and we'll get a little bit more into it with Charlie's comments. And, you know, legislation is, there's holes in this, right, that need to be clarified. We need to answer some questions. And although that is a little bit frustrating for some, it also provides the ability for stakeholders to shape policy through advocacy with USCIS, with the Department of State. And so there still is a lot of work to do. And our firm will be part of that process, and we're looking forward to it.
Joe, I want to clarify 2 points. The bottom line is there's nothing stopping you from filing a 526 direct today, correct?
Correct.
Is there anything stopping you from filing a 526 direct together with a 485 today, other than the note on the website that you need a approved 526 to file a 485? By law, you could file a one-step 526 485 direct, but the USCIS website currently prohibits that, correct?
That is correct. That's what the legislation says. It says upon enactment. So as of last Tuesday, you could one step for direct. And the question is whether USCIS will reject the filing and return the check, but I don't think there's any real risk to try. And
both we and other lawyers are already moving ahead on that. One of the things I want to clarify for everybody, if you have questions, you can put them in the Q&A, but we have a lot of material to cover, and I caution that most likely your questions, sorry, this sounds rude, will not get answered today because we just have too much material. If you do put in a question, it's got to be one sentence, very short, and in the Q&A, we'll try and get back to you as much as possible. Joey, the next slide, sir.
Yeah, so I'm just going to run through. To be honest, our PowerPoint isn't necessarily in line with what we're going to be speaking about, but here are some of the major changes that are in the new Reform and Integrity Act. Number one, they repealed that old Section 610 of the Department of Commerce and Justice. Everything that the old regional center program was based on, that legislative authority is gone, and they have created a new regional center program. They increased the minimum investment amount, but they decreased the differential between, I'm just going to use the term regular EB-5 and those who invest in rural, high unemployment areas or in an infrastructure project. So before it was at 500,000 and 1 million. Now we're at 800,000 and 1,050,000. So it went from 500,000 differential to a 250,000 differential. Now only the Department of Homeland Security can make determinations on whether areas qualify for high unemployment or as an infrastructure. An unanswered question is when they are going to do that. Is there going to be a pre-approval process, or is that going to be part of the I-526 processing? And these determinations are good for 2 years, and you can get extensions on them. The legislation provides for reserve visas in the annual numeric limitation for EB-5. 20% of those are supposed to go to investors who file in rural projects, 10% to those who file in high unemployment areas, and 2% to those who apply into infrastructures. Charlie's going to be is going to be doing a deep dive into that in just a little bit. For regional centers, before there was an exemplar option. Now it appears there's going to be some sort of exemplar requirement where a regional center is required to file project-related documents before an investor is allowed to file their I-526. It's unclear whether that exemplar needs to be approved before the I-526 filing. It's also unclear at this time what that means for EB-5 projects who previously had approved business plans and offering documents. One of the things that Bernie mentioned before, concurrent adjustment of status or subsequent adjustment of status for those in the United States with Form I-526 petitions. This is excellent because it opens the door to a green card for those who are in the United States, and it allows you to get EAD and advanced parole during the time in which your I-526 and your 485 is pending, which is excellent. Potentially, well, maybe not even better, but an additional thing that they put in was INA 245K protection, which was previously unavailable to EB-5 investors. And so now if you have up to a certain amount of unauthorized employment or out of status, that does not bar adjustment. And of course, the big thing that we're very happy to see, and it's at the bottom of this slide, is grandfathering. If there is a future lapse in the regional center program, and this will protect existing investors who file before September 30th, 2026. And I guess the other thing that I'd want to say is now the regional center program reauthorization is back in sync with the funding for the federal government. Whereas before it sort of got disconnected, that was part of Grassley's plan to get this legislation passed. And now we're back in with E-Verify and some of the other Conrad programs and other immigration programs. So there's plenty of things that we know. There's also a lot of things that we don't know. There have been reports that USCIS has begun to adjudicate regional center I-526s. USCIS hasn't mentioned that publicly, but we are hearing from attorneys that that is happening. It's unclear when NVC will start to send out fee bills. It's unclear when consulates and embassies will begin to issue I-5 and R-5 visas. There are a lot of unknowns still. For example, our regional center is going to have to refile for designations. That's one of the things that I think Senator Grassley mentioned on the floor, where Senator Cornyn came back and said the opposite. So they may not even know what's going on. And in the legislation, there are numerous parts where they talk about rulemaking. Some of them have time requirements. Some of them require it to be done under the Administrative Procedures Act, while others don't. And then there are also places where USCIS may not want to do rulemaking and instead do policy guidance to shape adjudications. We don't know to the extent to which they're going to be doing rulemaking on this. So that was a lot of rundown. One of the other things that we have here, the big thing is about the child status protection. So for those who have conditional green card status, if your I-829 is eventually denied, the parent can refile and the child who is over 21 can still be considered a child based on that new investment if it's done within 1 year of the termination, which is a great benefit. Potentially it doesn't go as far as we want, but it is still something and we should be happy about that. And yeah, we talked about the price increases. There's going to be automatic increases based on inflation every 5 years or so. I think they're supposed to do rulemaking on that aspect of it. And one of the other things that they have on there is about job creation limitations, where, you know, if it's based on construction, only a certain number of jobs can count, or if it's based on tenant occupancy, other certain number of jobs can count. So there are some new changes that economists and regional centers are going to have to take into consideration when putting together new project offerings, and those can hopefully be filed on day 60, which is, you know, that May 14th date. But it seems to me that USCIS is going to have to create new forms for the 924. They're going to have to create new forms for the 526, at least with regards to these new visa categories that we're going to get into. So it's still a little unclear on when folks are actually going to be able to file new I-526 cases. Bernie, anything else you wanted to add? I think you're muted.
Joe, you've done a very good overview and summary. We wanted to cover the big picture items. It's extremely important for folks to understand that Mr. Oppenheim is the Department of State. Even within the framework of the Department of State, Mr. Oppenheim's skill relates to visa allocation, relates to can perhaps give us some information on how the State Department collects numbers, how the visa bulletin works. But the other questions will have to go to either Joe or myself in terms of dealing with USCIS processing. Joe, that was an excellent summary, but I think at this point, the audience certainly wants to hear Charlie Oppenheimer's view on what this all means. This is early for Mr. Oppenheimer as well. The other thing that I would point out that in Mr. Oppenheimer's 43 years of service in the State Department, some almost 10 million, over 9 million immigrant visas were issued, and those are, of course, the quota subject visas, not the immediate relative visas. But Mr. Oppenheim has been responsible for all immigrant visas issued up until his recent retirement. So we're very fortunate today to have him join us. Mr. Oppenheim, over to you. Can we start off with the March Visa Bulletin? And if you could possibly explain, you indicated in the March Visa Bulletin, well, maybe we'll just let you explain. How did the March Visa Bulletin break out in terms of direct EB-5, number one, and then, of course, the Regional Center Program, which had lapsed, but then there was a provision in footnote F or G, I believe, which created an automatic conversion for the March Visa Bulletin. I appreciate if you could explain that to us, sir.
Yeah, when the March Visa Bulletin was published in early February, there was some potential for the Regional Center Program to be extended. So they listed both the category being unavailable and then the note indicating what would happen if the category were extended. That had pretty much been done for the last several months, and it gave the State Department a way to advise the public of what may happen. Then in the April Visa Bulletin, since there is some kind of room for interpretation in terms of the bills, this new bill's 60 days after enactment language, I do agree with the way the EB-5 dates are listed in that April bulletin as current for non-regional centers and unavailable for the regional centers. And they also included a note that there would be future updates since they are having to look into this issue. And I think that's pretty much about the best that they could have been expected to do with the passage of the bill and it being signed in just as the Visa Bulletin was about to be posted.
And so can you talk to us a little bit about what it means for, because in the Visa Bulletin, it says, if there is a reauthorization, then, China mainland will be subject to this backlog date. So is that where we're at this time?
No,
is it automatic?
At this time, I think that they were most likely considering that the regional centers are still unavailable effective for the month of April.
Which is interesting because chart B says current, and that's what USCIS says when you're looking at the adjustment of status page on their website.
Right. I think that what they were trying to get is allow for potential applicants to continue filing under the application filing dates in anticipation of some type of future action.
So, Mr. Oppenheim, I wonder if you could possibly just explain the Visa Bulletin, and everybody sees it, looks at it, follows it, but this is an instruction not only to the public. This is also an instruction to the National Visa Center. They take their guidance from the Visa Bulletin. Consulates abroad, in terms of scheduling interviews, they take their guidance from I want to say your Visa Bulletin, but I have to say your former Visa Bulletin. Can you just explain the significance of how the visa bulletin works? Because people are sort of a little bit frustrated. NVC is not issuing fee bills. Consulates are kind of ignoring the new law, even though it says immediate. So how does this March and April visa bulletin impact the agency broadly speaking? And I'm talking about Department of State. It's been, as Joey pointed out, quite generous from a USCIS point of view, in the sense that Chart B is open, and other than Chinese nationals, December 15, 2015, I believe is the cutoff date. So other than those particular Chinese nationals, everybody else in the US in lawful status seems to be able to file adjustments. So USCIS is I think going to get a deluge of 485 adjustments very soon. But for many of the EB-5 applicants, they're abroad and they're relying on your visa bulletin. So I wonder if you could just explain how that works.
Right. In terms of the dates listed in Chart A, the final action dates, those dates are based on the best information available at the time the visa bulletin is, the dates for the upcoming month are, the determination is made. And so that information is basically what's possible to happen in terms of final action on cases during the upcoming month. The Chart B data is intended to allow in the past and currently, the National Visa Center to notify applicants to that they can begin assembling certain required documentation and submitting it to the National Visa Center so that that information can be processed. If there's any problems with it, they can get back to the applicant and say, you need to update this information, you forgot this information, etc. And then that way, we had in the past, you have visibility into potential demand and have the demand ready to go. In the case of China, if the final action date were to advance, they already have people in the queue that are documentarily complete and could be scheduled for interview. In, I believe it was October of 2015, USCIS decided that they would like to also begin using those same dates that the State Department had always used, and they would use those dates and ask us to start, or ask the State Department to begin including Chart B with those dates that previously only the State Department had used. This would allow the applicants to file for adjustment of status, get the cases in the pipeline, because it would take USCIS several months to get the cases ready. And then at the anticipated time when we felt that those application dates would be reached, then by the movement of the final action dates, we would have demand, and we would also have visibility into the USCIS demand, which had never been really possible in the past before they started allowing this advance filing. In the quote old days, what happened is you had to rely on historical perspective. So if you had moved the date 1 week and that had resulted in USCIS using an extra 500 numbers, you would assume that if you move the date a week the next month, that would be 500 or whatever the historical pattern had been. Unfortunately, that didn't always prove to be the case, resulting in volatility in the movement of many of the employment final action dates. So again, this inclusion of the Chart B allowed to get more visibility. And unlike the State Department, once those dates are announced by the State Department, they are continually used throughout the year. And with the USCIS, they would make a determination of how long they would allow those dates to be used for filing before potentially saying, okay, only the dates listed in Chart A would be allowed to be used for future filings. So again, with these dates, the fact that they're current in regional centers are current for all except for China, which is December 15th of 2015, the State Department had already notified everybody that's eligible based on that. So despite the fact that the regional center program expired as of June, it really made no sense for us to change that listing because all of the eligible people that had filed with petitions on file at NBC had already been notified.
That makes total sense. So, Charlie, if we can push you out, I know you don't know what the May visa bulletin will be, but if you could comment on the May visa bulletin. And one other point as well in regard to scheduling appointments abroad. We know that adjustments, there seems to be a liberal policy, and we expect to see a slew of adjustments being filed. So USCIS will have the ability to use up some of the pipeline visas. But abroad, we have obviously the pandemic, COVID has impacted Guangzhou's ability. At its peak, Guangzhou was issuing almost 1,000 visas a month. Right now, that ability has been substantially reduced in terms of staffing, in terms of COVID. So I wonder if you could talk about a little bit, two separate topics, the May visa bulletin and the ability of the State Department to ramp up visa issuance in Guangzhou and possibly Ho Chi Minh City, other areas where there's high numbers of cases.
Right. And first, in terms of the May visa bulletin, based on the April visa bulletin's inclusion of the 60-day language, the comment on that, I would expect that the China non-regional center final action date would continue to be listed as current for the month of May. I would expect that the regional center date to be listed as unavailable through the 60th day after enactment of this new bill, for example, through May 14th. Then I would expect that, has been the case in the past, when a preference category has been scheduled to expire. For example, I believe in the March visa bulletin, the SR category was indicated that it was going to expire and no visas could be issued after a certain date. I think that the visa bulletin is likely to include a opposite note indicating that effective May 15th, a China Regional Center final action date would be applied for the processing of cases for the remainder of May. And my guess is that the China date would be at least November 22nd of 2015. And I believe that was the last date announced in June. Although they may decide to make a decision to advance that date by a month or more if they feel it's necessary to increase processing abroad. So,
where do you think we'll be in June? I know it's hard to sort of speculate. You don't have that much visibility, but what do you expect with June? And then June will take us close to the fourth quarter of the 2022 visa allocation, with the year ending in September. So we do know there's a lot of visa numbers available. The question, of course, people want to know is, when am I going to get my interview? And I was hoping you might be able to comment on the June visa bulletin and that issue of scheduling interviews for people who've been waiting a long time.
Right. I believe that there will be a single China EB-5 final action date listed for both non-regional and regional centers effective June 1st. I believe that for all other countries, both the non-regional center and regional center final action date will be listed as current. But again, China, I would expect a single EB-5 final action date to be listed.
But we don't know, of course, whether or not USCIS will continue to accept Chart B filings and whether they're going to rely on Chart A for adjustment of status filings. So that's why I want to distinguish between these two categories. we certainly don't know it. It would be unusual for USCIS to allow Chart B filings in May and June. So those people who are anticipating being able to file probably want to try and get their cases filed in March or April. Joe, do you have any comment on that?
I think the sooner the better. I mean, I think that's the move. They're trying to stimulate the demand, as Charlie said, and so if the option is there, let's get it in. That'd be my thought.
I agree. I would not leave anything to chance, but I think that the fact that USCIS has continued to allow the Chart B dates to be used is an encouraging sign that they may continue to do so throughout the year, or at least for several more months, in order to try to maximize new filings, and hopefully those new filings would allow number use to occur under the 2022 annual limits, because I'm sure they're attempting to maximize number use under the 280,000 annual limit, and to do so, they may need these new filings.
And I guess it's also, good. It's consistent with the legislation that you can file these concurrent or subsequent adjustments now, even before this 60-day period. Whereas if it was unavailable, or that's what they put in the AOS chart on USCIS's website, that could have been bad.
But also the negative view is that in the past, they haven't usually kept Chart B open beyond February or March. So the fact that it's open for April is an incredibly good sign, and maybe for May as well. Charlie, let's switch to the very big issue that I think the majority of our audience are interested in. Is we now have set-asides are not new to you. You've dealt with set-asides before. These may be different set-asides. I wonder if you could please explain to us what you think the Department of State might do. Of course, the State Department may not do what you may think they are, but what do you think? How do you think they will handle these new visa categories for immigrants? Are we going to have different lanes? Are we going to have different subcategories? What is your prediction in terms of how these rural, and Joe, maybe you can pull them up on the slide as well, the new categories we have: rural category 2,000, the so-called reserve visas or set-aside visas, 1,000 for high unemployment, 200 for infrastructure, and then again, all of them will be subject to the 7% per country limitation. But how do you think this is going to, what's the visa bulletin going to look like when this is implemented, in your opinion, sir?
And sorry, before you even talk about that, Charlie, I should say that these numbers on the slide here are assuming a 10,000 limitation. It's really 20% for rural, 10% for high unemployment. So when there's more, when we have the 19,880, those reserves also go up. So
that's true. Joey,
yeah.
You should have had the percentages in there,
Yeah.
because now those are important. But
Yeah.
Thanks for correcting.
Yeah.
I do believe that the State Department will need to have new visa category and issuance codes or issuance symbols need to be established to identify the applicants who are going to be eligible for processing under the 10, 20, and 2% set-aside limits. And this may actually eventually result in there being 5 EB-5 listings in the visa bulletin. Right now, there are only 2 for non-regional centers, and the regional centers, again, with the establishment of the new codes to cover the set-asides, I think that is likely to go to 5 listings. But based on the amount of EB-5 numbers that are available under the 2022 set-aside limit, the identification issues, it's going to be hard to identify who is and isn't eligible to be processed. And it being so late in the fiscal year, I would expect the set-aside limits to remain current for all countries for the foreseeable future. Really, the only reason I can estimate for establishing a set aside dates during fiscal 2022 would have been if the reporting issues can occur much sooner than I anticipate in getting information to the State Department, or if a decision is made to implement a quote safe date in anticipation of high demand, and then they could always advance that date at a later time. But they may want, like I said, with a safe date, they may want to kind of draw a line in the sand for initial dates.
Charlie, I wonder if we can deal with another really big issue, which is already approved petitions. You had explained in the prep that as a general rule, the agencies do not like to give preference to these newly filed cases over the thousands and thousands of people sitting in the waiting line. Can you address generally, of course, what your view is on that topic?
In terms of the people, right now, you go first in, first out. So the people with the earliest priority dates under the various categories and within the per country limits, our process would be eligible for processing first. And if there are otherwise unused numbers under the overall limit, then those numbers could be made available as they have in the past to the Chinese applicants, since they typically have the earliest final priority dates. They get the use of any otherwise unused visa numbers.
And I want to point out one other fact, which is, and I think, Joe, Charlie can't comment on this, but you might be able to. I mean, the reality is petitions have been taking 2 to 3 years to get approved. I mean, there's talk of expedites, etc. But these new filings under these new categories probably won't get to the State Department. And I know you can file based on pending, you can file adjustments on pending, but you can't process abroad. So before these new cases sort of get into the system and become a substantial part of the system, basically it could be 2025, 2024 before we even see approvals under these new categories unless they're expedited. Is that more or less, Joe, what we expect? Charlie, I don't really know if you can comment on USCIS processing times, but at the end of the day, when you use the word visibility and calculating demand, you've got to see approved petitions under the designated category before you can allocate them abroad. Hope I'm adequately clear on this.
Yeah, I think you are. Sorry to cut you off. And I guess to go on top of that, it's to report demand for visa categories, the Department of State needs certain information. In the current approval notices, it doesn't distinguish between high unemployment or rural or infrastructure. That's not a thing now. But, we're not going to see those in approval notices for a couple of years is what Bernie, I think, is trying to say.
Yeah, that's what sorry, I was not very articulate there, is that the problem for the State Department is you may know which category to put them in, but they may have to go back and look at all their prior approvals and give them some new code and issue new approval notices in order for State Department to have the data they need to allocate. And I think one of the points you'd made earlier, but I want to emphasize, is that normally when we have a new bill like this, they will do this at the start of a fiscal year, so October 1, and then they have time. But now this is like changing the tires on a moving car. It's kind of quite difficult, right?
Yes, and it's important to know that the use of the new codes to distinguish the 20, 10, and 2% set-asides is going to be necessary for Department of State to compare the amount of numbers which have already been used in those categories, the amount of documentarily complete demand ready for immediate processing, and to know the potential demand requiring use of a number in the future. That information is used not only for these set-asides, but for the determination of any of the preference categories' final action dates. And it's necessary so that it can, to apply that to control number use under the respective limits. So therefore, it is going to be very important for the officers to know which of the visa codes to be used for final action on a case so that the number can be accurately tracked and then reported to the visa office for numerical control purposes. So, and, you know, unfortunately, my previous position did not require me to know the detailed information which is included on these petitions. So I can't really say how easily it's going to be for them to make that distinction between the rural and high unemployment applicants for these set-asides.
But the bottom line is we don't have that. Sorry, Joe, I cut you off.
Go ahead.
Well, I wanted to move on to the question and drill down a little bit on reserved visas. This is a new term for many of us lawyers, but it's not really a new term for you. You've very familiar with the Immigration Nationality Act. What I'm kind of concerned about, and I mentioned the point that it may take a long time before we actually get approved petitions under these reserved categories. But my question really focuses on, let's assume that we do not have 2,000 rural visas allocated. There's just not enough filings in fiscal 2023. How will the leftovers, or can you speculate a little bit about how the leftovers will get recycled? What happens with those? Are these reserved visas, and I know, Joey, there's also statutory provision here, they carry over for 1 year. What happens after that? Are they going to get lost? I wonder if you could just help us understand the statutory framework for the allocation of the reserved visas, which we've addressed, and now the allocation of the unused reserved visas, because we think there's going to be quite a few of those in the next few years.
Right. It's an interesting thing, and this is one of those issues where it would have been nice in an ideal world had the effective date of the new changes been October 1st, so there would have been plenty of time to analyze this a little bit better and make some decisions. But in one way of looking at this, the INA guidelines clearly state how unused numbers within a preferences annual limit should be made available to other preferences. For example, Section 203B1 indicates already that any unused employment fourth or fifth preference numbers should be added to the EB-1 annual limit. Also, Section 201C says that any unused numbers from the previous year's worldwide employment limit fall across and are to be used in the determination of the next year's family-sponsored annual limit. So that despite the fact that there are these set-aside provisions, I think it could be argued that the current year's unused set-aside numbers could be made available to other EB-5 applicants. And then if there were still unused numbers under the overall EB-5 limit, such numbers could then fall up for potential use in EB-1 during the current fiscal year. And if you followed that logic, then the only numbers that were ultimately remained unused after the follow-up provision would then fall across for the next year's set-aside limit. I know that's a little confusing, but I think that there's room for interpretation, and it can be argued either way on this.
So what you're saying is that these unused visa provisions are a bit at odds with other legislative language in the INA. And I guess my question to you is, what's the process by which the Department of State will kind of come up with this determination? I mean, I imagine lawyers have to get involved and you know, maybe some coordination with DHS. I mean, how does that work out?
Yeah, I think an oversimplified answer of what would happen, at least prior to my retirement when I was involved, that there'd typically be a collaborative effort where myself and other interested parties within consular affairs would discuss how we interpreted a new bill's language and how we believed that the changes should be applied. Often during those discussions, we would also consult with other agencies to gain their perspective, or our decisions would be shared with them once they had been made. And then, as you are well aware, then any proposed changes that are made, they would be made available for public comment, so that such public comments could also be taken into consideration before any final changes are made to the FAM, et cetera.
A really sort of curveball question. I remember with MAC 90 and whenever we had major legislation, it was clear that Congress hadn't figured out all the details and they had to pass, I believe it was MTINA, the technical amendments to that act. Is it possible that, you don't have a crystal ball, that this may actually need some technical amendment to clarify between the existing provisions of the statute and the somewhat rapidly, and I'm going to say perhaps not clearly thought through provisions in this bill?
Yeah, I think that there are likely to be a need for technical corrections. Again, in an ideal world, the effective date would have been October 1st, so that everybody could have gotten together and requested clarification or suggested technical corrections before the bill actually went into effect. So I do think that there potentially will be some changes, at least to the language, to clearly identify what is meant. Because, for example, on this set-aside provision, where it's saying, okay, if there are unused numbers under the 20% set-aside, that those numbers should be reserved and added to the next year's limit. That is fine in regards to the EB-5 applicants, but if you're an advocate for EB-1 or EB-2 or family fourth or any other preference category, you may be saying, well, why can't we have the same benefit where our unused EB-1 numbers are reserved for the next year, et cetera? That type of, quote, reserved for the next year previously has only occurred through legislative action to recapture unused numbers. So this is a kind of a whole new world. And again, that's why I think it's going to be important for, to clearly interpret how you distinguish unused numbers.
Charlie, I want to jump in here and give a shout out to my colleague, Ron Klasko from Klasko Partners. Ron very kindly prepared a lengthy list of questions. His insight and ability and skill in analyzing statutes is almost unsurpassed. So again, big shout out. Thank you, Ron, for taking the time to prepare these. And a lot of these questions are actually just a rehash of what you submitted to us. So big shout out and thank you for your input on these issues. I want to come back to a very basic question, which I don't think you can answer accurately, Charlie, but we filed cases, and I'm thinking now of my clients, Chinese investor clients from 2015, 16, 17, a lot of their kids aging out. Can you give us some guesstimate on what you think will happen to those long lingering waiting cases with 2015 and 16 priority dates? This bill to me does not seem to be particularly helpful to those long waiting cases, but can you put that into real terms? Do you think the line may move faster, slower? What are the potential solutions for those folks who invested in 2015 thinking they were going to have a 3 or 4 year wait, and now they're still lingering?
Right. Looking at this issue, I think that there were a lot of filings in September of 2015 when the 3-year pilot program was scheduled to end. So there was a massive amount of filings in the month of September, and there was a fair amount of filings in the following months. And so there was kind of this bubble of potential demand that needed to be addressed through the forward movement of the final action dates in the past year or so when the regional center program was still in effect. So once that bubble kind of is past, the potential for movement in the China final action dates would increase somewhat. Another issue was in my discussions with the National Visa Center prior to my retirement, and this was going on for probably a year earlier. So a lot of it may have had to do with people not wanting to submit documentation during the COVID period because they knew cases were not being processed. But they were saying that the response rate when they would send out the notification to the applicants or their agent of choice, asking them to submit documentation, the response rate of applicants providing all of the documents required to be considered documentarily complete was relatively low. So again, sometimes, this may be an indication that they could move through the quote bubble demand at a faster pace if people are not choosing to become documentarily qualified, which is required for them to be considered for scheduling of a visa appointment.
And those, of course, now, if they are physically present in the United, I don't want to get into the issue of B2 entries and visa fraud, but let's assume we had a student in the US on an F1. Now, this option of potentially being able to file adjustments. So if we see the China date move past 16 or 17, there may be options within the framework of the adjustment. Charlie, I don't know if you have any other critical points you want to share with our audience today. If not, I will, recognizing our time and respecting your time, perhaps shoot to a few questions and see if we can answer any of those. But I wanted to make sure that all of the key information you have is shared with the audience.
Going back to one of your previous questions about Guangzhou processing, without knowing the extent of what Guangzhou will be able to process in terms of the EB-5 cases, it's kind of difficult to know what number use is going to be through September. But I would estimate that there's going to be at least 10,000 unused EB-5 numbers under this year's annual limit. It's also important to remember that normally the goal is to maximize number use during the first 8, maybe 9 months of the fiscal year so that there are fewer numbers remaining in the summer months. And the reason for that is during the summer months is when most of the foreign service staff overseas is subject to transfer from post to post or post to the States. There are also, at the same time, there are typically surges in non-immigrant visa demand, which can impact immigrant visa processing if any of the IV staff needs to be pulled to help out with the NIV workload. So those staffing and NIV issues could increase the amount of unused numbers to be much higher than the 10,000 that I have estimated.
So, Charlie, just so I understand, despite all possible efforts, the reality is that we had a double quota this year of about 20,000. At least half of those are not going to get used. And I think in the prior year, let's clearly blaming COVID. I don't want to get political, but because of COVID, the State Department was not able to issue the full quota either. So guesstimates go anywhere from 20 to 30,000 visas in the 2022-2023 fiscal year. EB-5 visas have and are likely to go unused. That's a rough number.
Yeah.
it seems to me that with some 50,000 Chinese in the queue waiting, that would have wiped out most of the backlog, just the quota for the last 2 years. I wonder if you could comment on that. I know that Congress doesn't like to recapture visas, but the reality is, had they done so in this recent bill, the China backlog would have pretty much been cleaned out, but it did not. So we're going to continue to advocate for that as lawyers to protect our clients who've been waiting. But I wonder if you can comment, is any of that more or less accurate? We don't have exact numbers, of course.
Yeah, I think it's very accurate. It's important to remember that Guangzhou was typically, and China number use was typically in at least the 50% or close to 50% in recent years of total all EB-5 number use. And with the extremely high fiscal 2021 and 2022 annual limits, as you say, had processing been possible at normal levels, the China backlog, although it would not have been eliminated, I think it would have been reduced to a more understandable and manageable, maybe wait time of two years or so, which is often the case in many of the other employment categories for other countries. But again, yes, you are absolutely correct. The backlog could have been addressed very nicely. And in the past, there have been numbers recaptured under legislative action. That is always a possibility, but it's a hard thing to get past. There was also in the American Competitiveness Act of 2001, there was a provision to address family second preference applicants in the 2A category who had petitions which were deemed to have been pending for an excessive amount of time, which allowed those applicants to come in under a non-immigrant visa under the V visa classification. So something like that is always an option for addressing any type of excessive wait time issue. But again, the backlog either recapture would be a nice one as well.
But that would have to be done statutorily. I mean, that
Yeah.
cannot be done by regulation. And we've just missed, I don't think Congress is going to be too excited about starting a new debate on EB-5. So in reality, without statutory intervention, it seems that we're going to lose somewhere between 20 and 30,000 visas, which would have resolved the, and I'm going to have to use the word pathetic, waiting line that many Chinese applicants have had to experience. So,
sorry, can I just paraphrase and try to paraphrase what you mentioned before, Charlie, and just let me know if you think I'm getting this right here. You think that the Department of State's going to have to create new visa categories to deal with the different reserve visa classes. You don't necessarily know how the existing investors are going to be included into those new visa categories without further action by either investors or USCIS or some way to report that demand. And with regards to the unused visa provisions, there's going to have to be some interpretation and discussion in DOS about how that's going to play out and how it's going to fall up or fall across. Those are just kind of unknowns at this point.
Correct.
Yeah. Okay.
Thanks for clarifying, Joe. I think that was really important because that is, I think, the reason why we have several hundred people register for today's event. They want those answers. Unfortunately, we're going to probably have to wait a little to get clarity on it. The good news is that in regard to USCIS filings, there seems to be some doors opening. In regard to getting past the 60-day, there seem to be some new filing opportunities. The bottom line is that the program is back. It seems to be incredibly popular. People We're getting calls nonstop for people who want to use this opportunity to immigrate, students whose OPT are expiring, people on H-1Bs who are running out of time. There seem to be a lot of folks willing to make the investment of $800,000 now, and potentially $1,050,000 if you do not qualify for one of these special handling cases. Our basic time is up. I'm not sure how many questions
There's a lot.
we can get. Charlie, there's one here. Please feel free to say no, but it's about the Hong Kong quota. I don't want to get in the weeds on this one. Hong Kong was excluded on the lottery, but I see from the visa bulletin, Hong Kong is not included with China, and that's the way the State Department is currently interpreting it. Is that correct, sir?
Correct. For immigrant purposes, for family and employment, Hong Kong is treated as a separate foreign state.
Thank you. I will tell you there's going to be a big sigh of relief for people hearing that. And thank you to the State Department for that correct interpretation. The next question I have here from Steve Parnell. Do the reserved visa categories create even longer delays for mainland Chinese as 2,200 visas are carved out in all years? I think we got an answer to that, but it's a very straightforward, clear question. Do the reserved visa categories create even longer delays for mainland China with the fact that 2,200 visas are being pulled from the general category?
I think there is the potential for that, although it's unknown how many of the Chinese applicants that are in line may be able to benefit by this new set aside. I think that is one of the unknowns at this point, and I don't think it's worth worrying about too much until we know in terms of the official determination on the implementation of the set-asides.
I'm just taking these from my friend Austin Kim. Hi, Austin. For direct investment projects, since only a single investor per project is allowed, that's true. No longer pooled for direct. There's no such thing as direct pooled anymore. It's direct single. What happens to the previous direct investment projects, which are still recruiting additional investors to fill their required capital stacks? That would have to go to you, Joe. I think this is not correct. They should not be continuing to solicit investments. If it's a pooled project, the documents have to be redone and they have to show they qualify as individual. Is that correct, Joe?
Yeah, so they can either try to qualify under a regional center in 60 days or do a restructuring of the project so there's only one EB-5 direct investor in a project, or potentially find other ways to raise the capital needed to complete the capital stack.
Wendy, to answer your question about filing separate 829s for other members of the families, what you refer to as derivatives, there's no problem with doing that. You can generally file in one application or you can file them separately. We encourage one if possible. Here's a nice simple question which we cannot answer. What is the timeline for Indian investors? Let me go to you, Joe, first and see if you want to have a shot at that. Let's just take an Indian investor who invests in a high unemployment area. What are you going to tell your Indian clients? I know they're calling you right now, Joe, so you have to answer this after the call. What are you going to tell them?
Well, we tell them at this point it's a bit unknown. We have to wait for the I-526 to get approved and for a visa to become available. So if there is that 10% set aside, and like Charlie said before, there's the per country cap on that set aside, then, I guess there'd only be, a certain number that would be given to an Indian national every year. And we'd have to wait to see the demand to see if any of the leftovers could be used. It's an unknown. It's an unknown right now.
India rapidly moved into what I'm going to call second place in terms of the number of investors, maybe even first place. Large demand because of the long waiting lines in EB2 and 3 and the difficulty of making it into EB1. So EB-5, very real option for many Indian nationals seeking to invest. Charlie, I went to India for the first time about 2 years ago. And after speaking to you, I think you had projected something like 7 years for Indian nationals, and most of the people were very disappointed. Turned out that was a little bit conservative at the time. Now, we still have to provide this advice. Clients want to know, is it worth it for me to file an EB-5 petition? Any possibility of a general prognosis for Indian nationals considering this is a solution? Is this going to, I mean, it's going to be better than EB2 and EB3. We know that, right? But what else can we say to help our Indian clients who have been languishing in EB-5 hell, if I could use that phrase?
Yeah. Oh,
EB hell, not EB-5 hell.
true. One kind of good thing that has happened in the past couple of years is because the amount of petition approvals being forwarded to the National Visa Center had declined. That allowed state to go through a lot of the pending India demand. And that's why India 5th went, for a period of time, there was a final action date. And then I was able to make it current because of the lack of incoming demand kind of refilling the pot. So it's kind of hard to say, when that 7-year projection was done, it was when things were flowing through at a pretty steady pace. So it's hard to see how things will continue.
I like this question here from Suzanne, who always has excellent insight.
I was going to grab that one. It's a good one.
It's really just about process, about all these uncertainties. And I guess the question is there any suggestion from you, Charlie, about how we can engage with the Department of State to kind of get our perspectives across to them? Is there anything you recommend?
I would, Bernie mentioned Ron Klasko earlier, and I think back to some of my interaction with Ron over the years, and I believe he's advocated in the past for an interpretation that only the principal applicants should be counted against the EB-5 annual limit, that it was an oversight potentially in the original drafting, that the intent was only for principals to be counted. If there were technical corrections to occur to this bill, since they've kind of gone off on this tangent with set-aside numbers, with those set-aside numbers being carried over to the next year, maybe they would be willing to entertain, making a change to say that only the principal is counted against the EB-5 annual limit, not derivatives. If that were to occur, it would allow for tremendous forward movement of the China date. Bernie, the India issue you mentioned would most likely go away. That would be about the best thing that could happen to the program if only principal applicants were charged against the annual limit.
I would have to say we may have to wait after midterms because I doubt, quite frankly, this Congress is going to do anything that they perceive as letting more immigrants in. I have another good question from Suzanne. Thank you, Suzanne, for this one. And by the way, Joe, can you just find Ishan's question? Because thank you, Ishan. A big shout out to you for protecting those people in line. Your work, you guys worked so hard on this and it was in the bill. So big shout out to the association for successfully preserving. We won't have to go through this 8 or 9 months of anxiety should there be another lap in 2027. But Suzanne's question, thousands of Indians and Vietnamese with pending I-526s are now eligible to concurrently file 485s. So many of the Indians, not so many of the Vietnamese, but many of the Indians are present in the United States. How and when will the Visa Bulletin likely react to this. So when do you get visibility if somebody files a 485?
Question.
My understanding was that USCIS does report this information to state quite regularly, and I think this is a very important question.
Yes. For the past several years, when I was with state on a monthly basis, I would receive reports from the National Benefit Center indicating the amount of demand USCIS had in each of the various employment preference categories. And at my request, they would give me the information by specific country, particularly the oversubscribed China, India, the Philippines sometimes. So there would be visibility into the demand. The other benefit of applicants being able to file for adjustment for those that are already here, it would be easier for USCIS to ramp up increased processing capacity than it would be for overseas. Because overseas, the State Department may wish to expand processing, but because of space limitations at their embassies or consulates, they don't have the capacity. And in order to get increased capacity, they would have to negotiate with the host country to get approval. USCIS is not faced with those same constraints, so they could potentially hire new staff and have some of their existing or new facilities to process these cases. So you may start to see them come to final action at a faster pace.
We have a nice simple question here, which we may have touched on, but when do you expect NVC to resume interview process for China Guangzhou consulate? I think the answer is now, but I don't know. Do you have any clarity on that?
Yeah, I haven't looked for a while, actually, since I retired, but on travel.state.gov, there isn't a link to shows what the various posts are doing in terms of processing. There is also was a link to showing NVC's, quote, backlog of cases in the pipeline. So there were two pieces of information available at the past. I assume that they're still there, that would give some insight into what's happening at the posts. I know that Guangzhou was eager to get back online processing. Again, I don't know their capacity to do so in terms of staffing.
So we definitely have a hard drop at 2:15. I do want to point out there are a lot of questions from what I'm going to call the Charlie fan club here, thanking you for being available. You certainly have, with the chats with Charlie, which we all missing already, appreciate you providing some clarity. So here's one that I want to take from Bruce Stewart, a friend of mine. What happens to pending 526 petitions in cases where the RC projects are completed and investments returned to the investor? I think that's got to go to you, Joe. What happens to a pending 526 petition in cases where RC projects are completed, investment returned to the investor? They've got to redeploy, right, at the end of the day. But
yes.
The good news is, in terms of this bill, they're not geographically limited. They can redeploy anywhere throughout the United States. Is that correct, Joe?
Yeah, and that's if it goes to the NCE. If it goes to the investor, then it's no longer at risk. So can't go back all the way to the investor. It can go to the NCE. I guess, again, maybe to paraphrase, and Charlie, correct me if I'm wrong, is that the answer of these reserve visa provisions, which are effective now, we don't know whether they are going to be impacting existing investors in the pipeline or how, right? I mean, that's kind of the answer. We just we don't know.
At this point, I think that's, an area for discussion, and a determination of how to apply that will need to be done by State Department and USCIS attorneys.
Okay. And I'm going to double down on the question that I already asked in terms of engagement with DOS. They don't do at least I don't know if the way they have public engagement, the way that USCIS may do, or listening sessions or things like that. Do you know if they would be willing to do something like that? I mean,
I think it would be possible. I would suggest contacting the Consular Affairs Press Office to check with that. There are, liaison groups between the visa office and various groups such as ALA. So there is an avenue for discussion. And I think that at a time like this, where there is some potential for ambiguity and interpretation of the bill's language, I think that the more minds getting together and having input, the better. That was what I always enjoyed. Sometimes people said, "Why do you engage with outside groups so much?" I always felt it was best to get as much information from a variety of sources so that I could make a better informed decision. So hopefully they would, like I said, would entertain. I would suggest either going through the Consular Affairs Press Office. They would be my first stop.
thank you.
Well, Charlie, we really appreciate you taking the time. I'm going to take a last question from my friend Diane Butler, because we get this all the time, and I'm going to throw it at you, Joe. The 829 receipt notices, they were giving 18-month receipt notices. They changed that to 24 months. So you can use this new receipt notice for up to 24 months after the conditional green cards expired. The question here is, will USCIS CBP honor that for 24 months after the I-551 stamp? I think the answer is no, and that you need to go and get a new 551 stamp. Is that correct, Joe?
Correct. Every year they'll have to issue a new I-551 stamp on your passport. They're usually good for 12 months unless your passport expires. And I guess this is maybe a shameless plug to do mandamus action on some of these unreasonably delayed 829s, which we are having a lot of success on.
I'd filed a handful of mandamus actions in the first 25 years of my career, and now, unfortunately, there seems to be no other way to move these 829s. Quite frustrating, because getting that 551 stamp is not easy. Some offices will schedule, and some will chase you away, and it's really haphazard. But let's not get lost in the weeds on this. We are losing some of our audience because we've been going for 1 hour and 15 minutes. I thank you again, Charlie, for taking the time to provide some clarity and visibility. We will get more clarity, hopefully in the next few weeks, but there certainly are opportunities within the framework of the current rules. Many of us are moving ahead. We're filing adjustments where we can. We're getting ready for the new stage of this program, and hopefully we can fix up some of the problems that have not been corrected. And I'm very grateful to Mr. Oppenheim for emphasizing the possibility of trying to recapture what I'm going to call the wasted 20 to 30,000 visas in the last 2 years. So on that note, Charlie, thank you in retirement.
Thank you, Charlie.
Enjoy the family. Joe, thanks for your hard work. And thank you, everybody, for joining us today. I hope you've learned something, and I do apologize that we can't answer all your questions yet, but stay tuned for the next one, and maybe we'll have some more answers on the remaining issues. Thank you, and have a wonderful springtime, everybody. The world is coming back to almost normal in some parts. Thank you so much. Bye-bye.